Hey there, listener! I hope you are doing well. Welcome back to this week's episode of That's Debatable with Jasmine Campos. I hope you have had a great week since we last spoke. I hope you are getting back into the swing of things and that you are returning to work or school or whatever it is that you might be doing in a non pandemic world. I know things are starting to hopefully look up. I just recently heard this week that in LA we are looking to move to our orange tier, which means that we might have good attendance for Dodger games when that starts back up, which is super exciting. I know I'm ready to get back into the swing of things and kind of jump in full fledged. So I hope things are opening up where you are. I hope things are getting back to somewhat normal. You're getting vaccinated if you're able to, and we're moving closer and closer to the end of this. So, with all that being said, unfortunately, things are not getting significantly better as far as the political sphere in America. We are facing the same problems that we faced before the pandemic. Things are coming to light, and we're having to wrestle with some of the same questions that we've been dealing with for a long time. So, today I want to talk about one of those issues, as I have been for the past couple of episodes. And today I want to focus on an issue that has been in the news a lot lately and that many people are talking about. And I want to just bring to light what I think is the most objective and reasonable way to that both sides approach the issue. And I know this is a highly controversial issue. I know this is going to be contested. I know this is going to be controversial, but I'm going to do my best to approach it with as much objectivity and rationale as is possible. So, with all that being said, today I want to talk to you about the Second Amendment. I want to talk about gun rights in America. So, to start off this discussion, I want to focus on things that have been being talked about in the news. So, this has been in the news cycle for the last couple of days since the mass shooting in Georgia, and then there was another one in Boulder, Colorado earlier this week. And so, before we delve too far into it, I do want to cover both of those instances. So, I want to talk about kind of what happened. I want to talk about the guns that were used and things like that. And I want to be clear at the outset. I do agree with the principle that speaking the names of these mass shooters does give them credibility. And regardless of how big or small your platform is, I don't think they deserve that. I think that is part of the problem. And so I will not be saying their names. I will be talking about the shootings without addressing their names in particular. So the first event that took place, horrible, tragic event that took place was on March 16th when a gunman was identified as having a sex addiction and he wanted to solve his problem, and he went to massage parlors that he believed were to blame, and he wanted to get rid of the problem. And according to the AP, what happened after killing 4 people and critically wounding another at the massage business in suburban Cherokee County, the lone gunman drove to a neighboring Atlanta and opened fire in 2 other spas. 8 people died altogether, 7 women, and 6 of them were of Asian descent. All were slain within about an hour. So this was done with a 9mm handgun, and 2 senior law enforcement officials briefed on the matter tell NBC News that the gun that was used in yesterday's shooting spree was purchased legally, and it was purchased prior to the shooting. Georgia law officials say that they were confident it was a 9mm handgun that was used in the shooting, and it was the only handgun they have found so far. The 2 senior law enforcement officials said the timing and the purchase of the circumstances did not run afoul to any government law or procedure. So that is kind of what happened in Georgia. It was a terrible, horrible incident. It sparked a lot of conversation on the internet regarding gun rights, gun control, Asian hate, just a lot of different conversations kind of sparked up, and a lot of people were talking about how sad it is that this is happening as the country is starting to open back up again, and kind of what that means for the eventual reopening, which is looking closer and closer. So this was kind of the initial shock to the system that kind of shifted the news cycle to more about gun control and about gun reform in America and what needs to happen. So that is the first shooting that occurred. And then the second one was in Boulder, Colorado, where 10 people were shot with an AR-15 inside of a grocery store. According to CNN, a search of the suspect's suburban Denver home turned up other weapons. A senior law enforcement source said to CNN on Tuesday. The weapon used in the attack was an AR-15 style pistol that was modified, according to the source. So these two events, this shooting in Colorado where 10 people died, they say that there's no motive for that one. There's not really a whole lot on it. We do know that the suspect was on the FBI's watch list because he was involved with another person who the FBI is currently investigating. So there is that information out there, but we do not have a specific understanding of why he did it, what his motivation was, what he was hoping to get out of it, why he was at that specific grocery store. But they have decided that there is no more fear to be had in the area. There is not much else to be worried about because he was a lone gunman and acting for purposes unknown. So with all that being said, this kind of sparked the debate about gun control, and it has been taking over the media, it has been taking over Twitter, it has been taking over everything possibly imaginable. Everyone in America is having this conversation right now, is debating gun reform, is debating gun control, is debating gun rights, is trying to understand everything about the issue and what they have to say about it. And this does not stop with just the citizens of America. This is going all the way up. And the President of the United States and the Vice President of the United States have both made statements on the issue and said what they believe is important regarding the issue. So first, I want to play for you both of those sentiments and what both of them had to say about this. This is first what President Joe Biden has had to say since the shooting in Boulder, Colorado that killed 10 people on Monday.
Let alone an hour, to take common sense steps that will save the lives in the future, and to urge my colleagues in the House and Senate to act. We can ban assault weapons and high-capacity magazines in this country once again. I got that done when I was a senator. It passed. It was law for the longest time. And it brought down these mass killings. We should do it again. We can close the loopholes in our background check system, including the Charleston loophole. That's one of the best tools we have right now to prevent gun violence. The Senate should immediately pass, let me say it again, the United States Senate, I hope some are listening, should immediately pass the two House-passed bills that close loopholes in the background check system. These are bills that receive votes of both Republicans and Democrats in the House.
So President Joe Biden really is honing in on what we can do to enact stronger gun reform. He is a clear advocate. He is saying he wants to quickly toughen the country's gun laws. He asked lawmakers to close loopholes in background checks, and he would like to ban assault weapons and high-capacity magazines. He wants to hone in on what is called the Charleston loophole, which is a provision in federal law that gives gun sellers discretion on whether or not to proceed with the sale if the FBI fails to determine within 3 business days if a buyer is eligible to purchase a gun. So he really wants Congress to act. He's really feeling pressure from the American population to act on this reform. He's really pushing it again. This is something that is not uncommon to him. As he mentioned, he did help pass legislation while he was in Congress doing this. So this is not really anything super new for him. It is also not anything new for the vice president. Vice President Kamala Harris is famous for saying on the campaign trail while she was running for president in 2020 that she would give Congress 100 days to act, and if they did not act, then she would take matters into her own hands and act. So this is kind of what that she is now wanting to still take that action as vice president, especially after these 2 shootings have occurred. So this is what that sounded like. She was on she was on CBS this morning for an exclusive interview to discuss the White House's push for stricter gun control regulations. And this is what that conversation was.
It's time for Congress to act and stop with the false choices. This is not about getting rid of the Second Amendment. It's simply about saying we need reasonable gun safety laws. There's no reason why we have assault weapons on the streets of a civil society. They are weapons of war. They are designed to kill a lot of people quickly.
Yeah, we all
Let
we
us
all
all.
So, Vice President, excuse me, Kamala Harris going out there again and touting the same message that President Joe Biden is touting. They are both very heavily fighting for stricter gun laws, fighting for stricter gun control. This is something that both of them have been saying for a while. It's not terribly shocking. It is pretty expected and pretty predictable from these two individuals. So, something that is a little shocking from the Biden administration is that White House Press Secretary Jen Psaki has come out and said that Biden is considering executive action. She said, "We are considering a range of levers, including working through legislation, including executive action. That has all been under discussion and will continue to be under discussion," Psaki said. So, the difference in approach here is that President Biden is considering executive action. He is considering anything that will help him pass more gun control legislation. The president is very clearly passionate about this issue and really cares about where it goes. So, as I mentioned earlier, this has not been just happening in certain realms, but everyone is having this conversation. From Twitter to cable news to the highest levels of government, people are arguing over every definition imaginable. They're having conversations about what a mass shooting is, what a weapon is, what it means to bear arms, what the right to self-defense is, should we even have a Second Amendment? I mean, there's just so much conversation happening right now regarding what it all means, what should be done, should we go back to the 1994 bill, should we focus on more assault weapons bans, should we, like, what exactly should be done to prevent this from ever happening again? And I do want to break that down, but I want to start off my discussion of the Second Amendment by saying I want us to all go into this understanding that neither side wants to murder. Neither side is saying mass shootings are good. Neither side is supporting. Just because you support the Second Amendment doesn't mean that you agree with a mass shooter. Doesn't mean that you agree that you have the right to go kill people. It doesn't mean that you agree that just anyone should own a gun. Believing in the Second Amendment is about believing in the right to self-defense. It's about the way that you read into what the founders wanted for the Constitution and what they wanted for the future citizens of America. So wanting to protect the Second Amendment is not inherently a bad position. That being said, not believing that we should have the right to own guns as individual right, but more as a collective right. Not believing that we have the right to whatever, not believing in a right to self-defense, thinking that that's more a personal decision than a political right. All of these positions that we can take on this issue, I want us to understand that you are not a bad person for disagreeing. You are not wrong. You are not crazy. You should not be ostracized from the debate. There is validity to this conversation as it is been had for years and years and years. And so the arguments that are coming up now are not new. They're not shocking. They're the same conversations that have been happening for years on end. And so I think it's important that we give each side its due credit, its due respect in listening to what they have to say. And I think that that's just something that gets glossed over so often, as people who support the Second Amendment are just gun-toting and they want their right to shoot and they're from the country, and people who hate the Second Amendment just want to throw away the whole Constitution and they don't believe in protecting people. And it's just, I think there, like with every issue, is validity to both sides. Obviously, that's why we're discussing it, because that is debatable. This is debatable. We're having the debate. So I just want to go in making sure people understand that there's validity to both sides, and it's important to understand both sides and respect both sides. And you can stand wherever you want on the issue. I stand where I do on the issue, and that's that. But understand that you are not inherently a terrible person for taking either side of this issue, and I think that's really important to say right at the outset. So, with that all being said, I don't want to talk about everything that the media is talking about. I don't want to talk about what kind of gun reform should be passed. I don't want to talk about what the right is proposing and what the left is proposing. I don't want to talk about the specifics or the details or what's happening on Twitter or what individual courts are ruling or what the laws of every state are. I think all of that provides a lot more confusion. I think it makes it really hard for people to care about the issue, but I think it's an important one, and I think it's a conversation that we need to have. So to have that discussion, I want to focus on something that I was tasked for school this week. So this week I am in this semester, I'm in a political liberty class, and within that political liberty class, we have had to break down the different kinds of liberty that exist in America, be it political, religious, economic, whatever it is. And this week I was assigned a Supreme Court case to read, and I just so happened to get one that I believe is perfect for this conversation. And what I think is so perfect about it is that it does not just tell us what the two sides want. It explains to us the fundamental differences in what we understand to be the Second Amendment. So, before I get into the case, I want to read to you the Second Amendment. It is rather short, it's rather concise, it's rather clear and to the point. So, the Second Amendment of the Bill of Rights, an amendment to the Constitution, which was passed in, I believe, in 1791, ratified in 1791, the Second Amendment reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Who would have thought that such a small and short amendment would cause so much debate and so much controversy? So that's the Second Amendment. It is the right of the people to keep and bear arms, and it shall not be infringed, or so that says the Second Amendment. So that is the amendment that was up for debate in this court case that I want to talk about. The court case that I want to talk about is probably the one of, if not the most referenced case on the Second Amendment that has ever reached the Supreme Court. The case is District of Columbia versus Heller. This case was decided in 2008. It was a landmark decision of the Supreme Court, and it ruled, eventually, the outcome of it, just to tell you at the outset, was that the Second Amendment was infringed upon by laws put in place in Washington, D.C., and that the right to keep and bear arms, the Second Amendment, this is the key part. The right to keep and bear arms mentioned in the Second Amendment is an individual right. So, before I get into anything of the implications, the opinion, the dissenting opinion, I want to talk about the facts of the case just to give you guys a little brief understanding. I'm going to go ahead and preface this again with I am reading a very convoluted, I believe the case is about 150 something odd pages. I tried to break it down as best as I could. I tried to understand the opinion and the main arguments of the opinion and the dissent as best as I could. I'm not a legal expert. I have read many court cases before. I do know how to read them. I tried my best to break this down as best I can. There might be things I missed. There might be points I missed. Just a total disclaimer. With that being said, so in Washington, D.C., essentially what happened was that Washington, D.C. decided to put some new laws on the books, gun legislation on the books. So the case dealt with restrictions that were placed on the residents of the District of Columbia regarding their right to keep and bear arms within their place of residence. So the law in question, what it did was it made it illegal to possess an unregistered firearm and prohibited the registration of any handguns. The qualification was that the police chief is allowed to issue 1-year licenses as long as residents can keep their firearm unloaded and disassembled or bound by a trigger lock. So the law was essentially saying you cannot have a handgun unless you have a license. The qualification is that the license can only be given to you by a police chief for a 1-year length of time, and if you have that license, you have to promise to keep your gun disassembled and unloaded or bound by a trigger lock. So this law was contested very quickly when a District of Columbia special policeman named Dick Heller, the that is referencing the name in the case, was denied a license to keep his handgun at home. Heller struggled through the court system. At first, his case was just entirely dismissed, and then he won in both the D.C. Circuit Court, and obviously he won in the Supreme Court when they ruled that the law did infringe upon his right to own a gun. So, this case was decided in, as many of our cases are decided, in a split decision of the court. It was a 5-4 decision with Justices Scalia, Roberts, Kennedy, Thomas, and Alito joining in the majority of the opinion, and the other 4 justices being a part of the dissent. So, with that being said, this is about gun rights. This is about specifically a law in D.C. that the Supreme Court decided infringed upon the people's right to bear arms. This is the part of this entire podcast that I have today that is so important that I want to focus on. The reason that the Supreme Court disagreed so strongly on this, the reason that we had a 5-4 decision that was so close, decided by one justice, the reason that this case is so important is because it undergirds the actual tension that is occurring right now regarding the Second Amendment. We can argue about the specifics of policy, about the specifics of law, about the specific kind of guns, about the specific kinds of ammo, about the specific kinds of magazines that should be allowed, that should be banned, that should be this. But this Supreme Court case exemplifies and highlights the actual problems that exist within American politics, the actual underlying philosophies of the two largest groups when it comes to the gun rights versus gun control debate. And so I think that's why this is extraordinarily important. So first, I will go through the majority opinion of the court. The majority opinion of the court was written by Justice Antonin Scalia, who wrote about many different things about the Second Amendment, but most importantly, what this case did was decide that the Second Amendment is an individual right to self-defense with any arms necessary. Those are the 3 main takeaways from the majority opinion of the court in this case. What Justice Scalia did was ensure that people understood that there is a right to self-defense that is inherent within the Second Amendment. So in his opinion of the court, Justice Scalia expressed 3 important takeaways. First and foremost, the Second Amendment is to be read as protecting the individual right to own a firearm. He understood that this was not an unlimited right, but that the laws in question did violate that right. He first addresses this by stating what he sees as the root of this problem, the true definition and understanding and intent of the Second Amendment. He does this by explaining what he believes as the right of the people means. And the dissent does a similar thing in breaking down the language of the amendment. Since it is such a short amendment, it's not too time-consuming or hard to do that. So what Justice Scalia defined the right of the people as is he talked about how it is mentioned 2 other times in the Bill of Rights. And he says, quote, that it is mentioned a few other times, and he says that 3 of these instances unambiguously refer to individual rights, not collective rights. He says that this is the essential understanding. For example, he talks about, I believe, the First and the Fourth Amendment in particular, that when you have the right of free speech or the right to assemble or the right to the press, or you have the right to not have unreasonable searches and seizures, all of these rights, when discussing the rights of the people, discuss the rights of the people as the right of the individual person to be protected against unwarranted searches and seizures, to be protected in their right of speech. It is not a right that is given to the whole. It is a right that is given to the definition of the people, which he understands to be the individual in this circumstance. So that is integral to Justice Antonin Scalia and to the majority opinion of the Supreme Court's understanding of the Second Amendment, is that it is not a right given to the whole, it is a right given to the people as understood as the individual. The second thing that he really wants to focus on is what it means to bear arms. So he understands this as he explicitly states that quote, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in the existence at the time of the founding. So he very explicitly states that he believes that the Second Amendment was not constrained by the understanding of what it meant to bear arms in the 1780s or 90s, but by whatever it means in that time period to keep and bear arms. He uses the kind of argument that the First Amendment does not simply protect against a pen or a quill and a piece of paper, but to all methods and modes of communication, no matter how fast, no matter how widespread. But as the First Amendment is adapting in that form, the Second Amendment so too shall be adapting. So that's kind of, he believes it's an individual right to any arm of the time period with restrictions, which he doesn't terribly get into because he understands it as not fundamental to the understanding of the of the Second Amendment as a whole. What I really, really want to emphasize now is what Justice Scalia understands the Second Amendment to be protecting. The crux of the argument made by Scalia in this majority opinion is that built into the Second Amendment is the inherent right of the individual to self-defense. Justice Scalia lays this out explicitly when he states that the most likely reading is that the Second Amendment secures an individual right to bear arms for defensive purposes. This idea is central to the argument of and defense of the Second Amendment provided for by the court. They believed and understood the Second Amendment to be a protection of self-defense, and in that circumstance, it's impossible to believe that those DC laws did not violate the Second Amendment. So he even goes so far as to say that the handgun ban amounts to prohibition of an entire class of arms that is overwhelmingly chosen for the lawful purpose of the inherent right to self-defense. This is the crux of the argument. This is essential. This is what you need to understand and take away from this majority opinion, this Supreme Court case, and this understanding of the Second Amendment. The part of the country that believes in the Second Amendment, that believes that the Second Amendment is the individual right to bear arms, believes without a doubt that the Second Amendment was not just the right to own guns, but it was the right to defend yourself and protect your family and your property. There is more behind just the desire to own a gun. It is the end to which the owning the gun would get you towards. It's owning a gun in order to protect yourself, not just for the sake of owning a gun. This is what they believed was inherent within the Second Amendment. Justice Scalia also mentions that he divides the amendment into two parts, and he talks about the prefatory clause and the operational clause, which is the fact that it says regarding a militia that because they should be able to have a militia, they should then have the right to bear arms. And he argues that one does not really have an effect on the other, that just because it mentions that, it's telling us what their thought process was, but that does not change the fact that the operational clause of keeping and bearing arms means that the individual has a right to self-defense with the arm of their choosing. And so that, again, I know I'm kind of reiterating here, but that is the crux of the argument, is that the Second Amendment is not just an argument for gun rights or an argument for owning a gun. The Second Amendment is the right, it inherently has within it the right to defend oneself. This is the majority opinion. This is the current opinion of the Supreme Court of the United States. It has not been overturned. It has been highly contested, but that is where we stand today. And so I think that is essential for understanding half of the argument. There's obviously another side to this argument, as 4 justices dissented from the majority opinion. And they had their valid reasons. They understood the Second Amendment differently. And as I mentioned, that's what's important here, is that it's not a disagreement on what the right mean. It's not a disagreement on guns or the specifics of what gun to own. It is more fundamentally an understanding of what the Second Amendment was intended for. So, in writing his dissent, Justice Stevens writes for the court, writes the dissent for the majority of those on that side. So it's Justice Stevens, Justice Souter, Justice Ginsburg, and Justice Breyer. So the dissent begins with a fundamental disagreement over the question at issue. Justice Stevens states at the outset that a conclusion that the Second Amendment protects an individual right does not tell us anything about the scope of that right. They believed very specifically that the Second Amendment was less concerned with self-defense than it was, and quote, the right of the people of each of several states to maintain a well-regulated militia. The dissenting opinion also broke up the amendment into different sections. However, they broke it up into kind of three instead of prefatory and operational. They broke it down into an introduction, what it means, again, what the people means, and then what the right itself is. So Justice Stevens wrote in super direct contrast to the majority opinion in mentioning the word militia. So the dissent focused very strongly on this word militia and focused on the fact that because the founders felt the need to include the word militia and prefaced the entire amendment with this word, that you then cannot read the right to keep and bear arms without understanding it in context of the fact that we are supposed to have, that was supposed to be for a militia. So he thought that we should keep that in mind when examining what comes next. He goes so far as to say that the people being referred to are not the people as individuals, as the majority opinion understood it, but the people are what is referred to previously in the amendment as the militia. So the people having the right to bear arms could easily be replaced and say the militia has the right to bear arms. So Justice Stevens points out that to keep and bear arms means this is one of the most telling and revealing points of the dissenting opinion. He says that to keep and bear arms means to possess arms if needed for military purposes and use them in conjunction with military activities. Obviously, this interpretation of the amendment strictly limits the rights of the individual as the way that the Second Amendment was understood from the majority. So the dissenting opinion really, really heavily focused on the right of the collective to have a militia, to be able to gather together as a militia if need be. Justice Stevens writes that when each word in the text is given full effect, the amendment is most naturally read to secure to the people a right to use and possess arms in conjunction with service in a well-regulated militia. So far as appears, no more than that was contemplated. So the dissenting opinion is that the majority opinion essentially wrote into the Second Amendment, is seeing into the Second Amendment a right to self-defense that simply doesn't exist. It's not mentioned, and if they wanted to mention it, they would have mentioned it, so why didn't they? That's pretty much the dissenting opinions. He continues this by saying the right to keep and bear arms protects only a right to possess and use firearms in connection with a service in a state-organized militia. He says after that, guns are used to hunt, for self-defense, to commit crimes, for sporting activities, and to perform military duties. The Second Amendment plainly does not protect the right to use a gun to rob a bank. It is equally clear that it does encompass the right to use weapons for certain military purposes. Whether it also protects the right to possess and use guns for non-military purposes, like hunting and personal self-defense, is the question presented in this case. The text of the amendment, its history, and the previous decision in the United States v. Miller provide a clear answer to that question. That is the crux of the argument of the dissent. This sentence The Second Amendment protects an individual right to self-defense with any arms necessary is what is so contentious about the Second Amendment. Whereas the majority opinion found it to be an individual right to self-defense with the arms that are necessary at that time, the dissenting opinion found it as a corporate right without the existence of a right to self-defense, only to be used in the circumstances of a militia being necessary. That is the general debate, the fight, the conversation, the underlying problems, morals, whatever you want to call them, to this entire issue. And obviously, this was duked out in the Supreme Court. It was decided 5-4, so it was not a clearly... It was a clearly controversial opinion. It was not easily divided. It was not explicitly one way or the other that they felt that they were taking a stand as a unified court. It was controversial, but that is really what the entire argument comes down to, is whether or not the right to self-defense is inherent within the Second Amendment, or it was intended to be read as the people is not an individual, it is the collective, it is a militia. The right to bear arms does not mean what we have always said, what the court has interpreted as, or it is the right to bear whatever arms are of the age. So that's really another thing the dissent pointed out, was that the right to keep and bear arms is one right versus the way that the majority read it as two. You have the right to keep and bear your arms versus the right to keep. You have the right to keep and the right to bear versus you have the right to just keep and bear. And so the dissent reads into that to say that the fact that they didn't say to keep and to bear, that you should keep and bear them for purposes when a militia will come about. Obviously, the majority opinion reads that as the right to keep and bear is, again, in the guise of self-defense. So that's pretty much what I have on that Supreme Court case. It's a long one. If you want to go read it, by all means. If you type in a Supreme Court case name, which is District of Columbia v. Heller.pdf, you can usually find them just online. A quick Google search will help you out there if you want to read it. It is rather long, like I mentioned. But I really think, rather than getting into the nitty gritty of handguns versus AR-15s versus assault weapons bans versus magazines versus the different laws in all of the country, I wanted to talk about what the fundamental different understandings of this kind of of the Second Amendment is, what it means to keep and bear arms, and how the two sides of the country don't just disagree on what kind of arms are or what it means to keep and bear arms, but we have a fundamental disagreement on whether or not there is an inherent right to self-defense and to protect one's family written into the Second Amendment. And so that is where I think we are. That is the conversation we're going to need to have. That is the fight that is going to be had. And so that's why I wanted to really focus on this Supreme Court case as opposed to everything happening right now on social media and cable news and being enacted on the internet. So that's what I have to say about that. To move into my biblical talk portion of what I usually like to do here, I think this one I struggled with. I struggled to find a great passage or verse or understanding of any of this within the Bible. Obviously, it doesn't explicitly talk about gun control or gun rights in the Bible. And what I think that I saw is I found an article written by a Mary Fairchild regarding the Second Amendment and the Bible and biblical self-defense, and I kind of just want to read over parts of it to you. So she writes, according to a conservative leader and wall builders founder, David Barton, the original intent of the founding fathers when writing the Second Amendment was to guarantee citizens, quote, the biblical right of self-defense. As many of the founding fathers recognized, Barton believes that, quote, the ultimate goal of the Second Amendment is to make sure you can defeat yourself against any kind of illegal force that comes against you, whether from a neighbor, whether that is from an outsider, or whether it is from your own government, end quote. She clearly addresses that the Bible does not specifically address the issue of gun control and that it is hard to find something that specifically addresses the issue, but she did find a couple Old Testament passages. So she says that when she talked to someone at her church, they brought up to her 1 Samuel 25:13, when the Israelites were expected to have their own personal weapons and every man would be summoned to arms when the nation confronted an enemy. They didn't send Marines, the people defended themselves. So 1 Samuel 25:13 reads, "As David said to his men, every man strap on his sword, and every man of them strapped on his sword. David also strapped on his sword, and about 400 men went up after David, while 200 remained with the baggage." So that's one verse where people are called to arms, and they do such a thing. And so, Scripture is, the problem with that, being from the Old Testament, Scripture is clear that Christians are also called to be peacemakers in Matthew 5:9, and to turn the other cheek when someone hits them, which is Matthew 5:38 through 40. So any aggressive or offensive or violence action was not what Jesus had told the people to do. So I think there is a lot of, I think there's good debate on both sides of this. I like I said, I struggled to find something with this. So I think that it is easier to argue for a right to self-defense than it is to say that we should be the ones being aggressive. I don't think that we would be called to be, to let ourselves die if we were put in that situation. I'm not sure that's what the Bible would argue. Again, like I've said every time, I'm not a biblical expert. I'm only going based off of what little research I could find. It was not an easy task. Jesus does say in one scripture in Matthew that put your sword back into its place, for all who take the sword will perish by the sword. So I honestly, to be completely honest, I could not find a complete and coherent understanding of what the Bible would inform us about the Second Amendment or the right to self-defense. We can only do the best that we can with the information that we have. But that's kind of where I feel like I ended up, was just God would not tell me to just stand down and let myself be hurt. So I don't have much more on the biblical side for you than that. I'm sorry. I know this was a difficult one. This was a hard one for me to wrestle with. But that being said, that is all I have for you today. Go with grace and peace into the world. Keep your prayers large, keep your worries small, and thank you for joining me on this episode of That's Debatable with me.